Hi, my name is Josh Blackman, and I am the president of the Harlan Institute. It's my honor to welcome you to the 2020 Harlan Institute Ashbrook Supreme Court competition. This year, we're arguing the case of Torres versus Madrid. We have here two teams we're very excited to hear from. For the petitioners, we have Campbell Collins and Gabriella Lovins. And for the respondents, we have Sam Niehl and Sharon Huang. And they will be arguing this case in a moment. So let's begin. Petitioners, you have 10 minutes whenever you're ready.
May it please the court. My name is Campbell Collins, and along with my co-counsel Gabriella Lovins, I represent the petitioner, Roxanne Torres. Ms. Torres was shot repeatedly by police officers. She was injured so severely that not only was her left arm temporarily paralyzed, but she also had to seek urgent medical care. This use of force by the officers was a seizure under the Fourth Amendment, and it was a seizure both based on common law and this court's precedents. Would the court like a brief statement of the facts?
Please.
On July 15, 2014, petitioner Roxanne Torres parked in the lot of an apartment complex. She was approached by the respondents, two police officers who were not in uniform. As they approached, Ms. Torres, who had used methamphetamine, ran to her car, believing that she was being carjacked. She accelerated, and both officers fired at her repeatedly, hitting her twice. The lower courts refused to consider whether the force was excessive because they found that no seizure had occurred due to the fact that Ms. Torres sought medical attention rather than submit to the people whom she believed were carjackers. The court should overturn that decision. The question presented in this case is whether officers commit a physical force seizure even if the suspect does not submit. Based on both common law and case law, they do, for two reasons. First, because a seizure is any application of force with intent to restrain, regardless of whether it succeeds in subduing a suspect. And second, because courts cannot limit the protections of the Fourth Amendment to be less than its protection at the founding. First, submission didn't matter. Based on founding era common law, any application of physical force with intent to restrain was a seizure.
But what sort of authorities from the common law are you looking at, Counselor?
Well, Your Honor, we have the case of Intick v. Carrington, in which the court alternated its use of the word seizure and the word arrest, and used them synonymously. And also the case of Ginner v. Sparks, in which the court held that if the bailiff had but touched the defendant, even with the end of his finger, it had been an arrest, and therefore a seizure under the common law.
So, Counselor, last question to Gabriella. I'd like to alternate a bit. Were those cases civil or criminal arrests?
Your Honor, I believe the Intick v. Carrington was criminal?
Well, in fact, they were both civil cases.
Excuse me, they were both civil.
However, the common law courts did not treat civil disputes differently from criminal disputes. And that's why these are authorities. And these authorities were also used to inform the court's decisions about seizure cases in modern times, such as in the case Hodari D.
Okay, well, now let me ask a question with Gabriella. I appreciate the response. Did Hodari D decide this case? In other words, is there anything left for us to decide that Hodari already resolved this one?
Well, Hodari D was a case about common law arrests and seizures, and it defined a seizure as either any physical force with intent to restrain or any show of authority, like an officer yelling, "Hey, stop in the name of the law," followed by the suspect actually submitting. The physical force seizure did not define a submission. So the reasoning there was following the common law definitions of arrest and seizure. And yes, this is the reasoning that should be used in today's case.
But was that the holding of Hodari D? Didn't Hodari D involve drugs?
Now, whether or not you technically could have come to the conclusion without the definitions of physical force and show of authority seizures, this was a quintessential part of their decision. So yes, this was the holding. And the reasoning in this case was those are the two types of seizures, one requiring physical force but not submission, one requiring a show of authority and submission.
Okay, you proceed, Counselor.
So this definition of a seizure was consistent with the original aim of the Fourth Amendment, which was to protect personal security, because British officers had been using general search warrants to arrest and search individuals on suspicion. And as held in Terry v. Ohio, the utmost violation of personal security is violating the sanctity of the person. And that's what physical force seizures do, regardless of whether the person submits.
Counselor, the word seizure seems to include possession. It seems to, if I seize an object, I have grabbed it. Why should it be different with people?
Well, Your Honor, because there is this common law tradition that is present that says that a physical force seizure in which officers apply force to a person is fundamentally different from the way that we seize objects. And that application of physical force violates the core purpose of the Fourth Amendment, which is to protect personal security, in a way that seizures of objects do not.
So now with the word physical force, again, force seems to be something more than just contact, right? Is mere contact enough to constitute force, physical force?
Well, Your Honor, when a suspect, or excuse me, when an officer touches the suspect, they have seized them under the common law definition of Ganner v. Sparks, which said if he had but touched the defendant, even with the end of his finger, it had been an arrest. Now, the flip side of this is there are not as many cases dealing with the touching without the officer touching with their physical hand. So there was a case, the Countess of Rutland, where the officer touched with a mace. However, we do have a clear answer from Brower, which was Brower v. County of Enyo, which was another clear seizure case. And they said it was enough that Brower was meant to be stopped by the physical obstacle of the roadblock. In this case, it was enough that Ms. Torres was meant to be stopped by the physical obstacle of the bullets. So in our case today,
The bullets didn't actually stop her, Counselor. Sorry to interrupt. The bullets didn't actually stop her. She kept driving for 75 miles. How can you say she was seized when she kept going? The police didn't stop her.
Yes, Your Honor. So in Brower, they define a seizure as a governmental termination of freedom of movement through means intentionally applied. This case came just years before Hodari, and both were written by Justice Scalia. Now, the termination of freedom of movement was not related to the question in Brower, as the petitioner Caldwell's death is the ultimate termination of freedom of movement. So at what point is freedom of movement sufficiently terminated as to be a seizure? What common law and Hodari D show us is that it's whenever physical force is applied.
So that means in this case that as soon as the force of the bullet hit Ms. Torres, that was the seizure. Now, it was not a continuing seizure. It stopped as soon as the force stopped. But that application of force was enough to satisfy both the Hodari definition of seizure and the Brower definition of seizure.
So if even the slightest touch, so long as there's intent to seize, can be considered a seizure, then aren't we going to have officers dragged into court for more or less any time they have physical contact with people? Wouldn't that create unnecessary backlog and chaos in our legal system?
I don't believe so, Your Honor. As when an officer touches a suspect with the end of their hand, that's not likely to bring up an excessive force case, which is what we're dealing with today. However, if there is a seizure that didn't lead to submission but was still a physical force seizure, it's good if that gets brought up because it forces our officers to be more accountable for not breaking the Fourth Amendment. We can't narrow the protections provided by the Fourth Amendment because it might cause more cases to be brought up.
And in addition, the protections of the Fourth Amendment today cannot be less than they were at the founding, and case law supports this. In United States v. Southeastern Underwriters Association, this court held that the court generally does not construe words used in the Constitution so as to give them a meaning more narrow than the one which they had in the common parlance of the times in which the Constitution was written. And when the Constitution was written, a seizure meant force with intent, with or without submission.
Now,
Counselor, sorry to interrupt. Do you think the phrases arrest and seizure are synonymous? I think you said that earlier, but is that your position?
Well, yes, Your Honor. In this sense, they are, because in the case Intick v. Carrington, the common law court used them interchangeably. However, while all arrests are seizures, not all seizures are arrests, because you can seize things other than a person.
And furthermore, in the Hodari case, they specifically said to constitute an arrest, the quintessential seizure of the person, which gives us clarity on that, saying that an arrest is a seizure. Now, by limiting the definition of seizure, there are unintended consequences that harm the rights given by the Fourth Amendment. The Fourth Amendment was designed to protect the personal security of people against government overreach. If an officer can get away with shooting an individual unreasonably just because they didn't manage to subdue them, they have still committed a violation the Fourth Amendment meant to protect against. In conclusion, because common law defines physical force with intent to restrain as a seizure, and because the court must not make the Fourth Amendment protections narrower than they were at the time of the founding, Ms. Torres was seized in a Fourth Amendment sense, and the judgment of the Court of Appeals should be reversed. We pray that this court will reverse the judgment of the Court of Appeals.
Thank you. With 10 seconds is fair. Very good. Okay. Can the respondents please come on camera and you'll have your 15 minutes. Okay. Begin whenever you're ready.
My name is Ruoya Huang.
And my name is Sam Niehl.
And together we represent the respondents, Janice Madrid and Richard Williamson. May I please the court? The question before this court is an unsuccessful attempt to detain a suspect by the use of physical force is a seizure within the meaning of the Fourth Amendment? Or must physical force be successful in detaining a suspect to constitute a seizure? The respondents will argue that an unsuccessful attempt to detain a suspect by the use of physical force is not a seizure.
Your Honor, would you like a brief statement of the facts?
Yes, please.
On July 15, 2014, Officer Madrid and Williamson were on the mission of arresting a female criminal when they saw Torres standing near the apartment of the criminal. When they approached Torres, Torres got into her car and started the engine, thinking she was being carjacked. The officers perceived that Torres was tripping out badly because of her consumption of methamphetamine, as later found out. When Torres ignored the officer's verbal command and drove forward, the officers fired 13 shots at the car and 2 bullets struck Torres. Despite being shot, Torres fled the scene, stole a car, and drove 75 miles to a hospital of another city. She was arrested at least a full day after she was shot. We believe this court should affirm the decision of the U.S. Court of Appeals for the 10th Circuit, ruling that officers Madrid and Williamson did not seize Torres during their encounter. The definition of arrest is usually taken from common law, which holds that 2 requisites have to be met to constitute a successful arrest. 1, the officer must display a show of authority or apply physical force, and 2, the successful detention of the subject. Cornell Law School confirms this definition. Given that Roxanne Torres was neither under the control or submitted to the authority of the officers, she was never seized.
All right, counsel, if I could just interrupt you. What is the most important common law authority you rely on for your definition of a seizure?
Well, we actually argue that common law is very malleable and is able to change over time. For instance, Petitioner uses Genevieve Sparks to justify that even the slightest application of physical force is enough. However, we align with the objectable reasonableness clause in, let me find the case here, in Graham v. Connor. Yeah, in Graham v. Connor. And we argue that actually the circumstances surrounding a situation should be considered instead of one single reliable definition such as slight physical force.
The counselor, in recent years, the Supreme Court suggests that we should look to the common law and look at how these rights were understood in England, but you're telling us we shouldn't look to that history?
Well,
No,
I'm saying,
Sharon can answer this question. Go ahead.
Okay, no, Your Honor, we're saying that in the essence of the common law of arrest, there are 2 requisites.
Hey, Sharon, maybe your headphones are not very good. Maybe unplug them and just use your computer because it's very hard to hear you.
Sorry, Your Honor, can you hear me now?
Much better, thank you. Go ahead.
Is it clear now?
Yeah, good.
Okay. Okay, so well, we're arguing that in the essence, the common law of arrest has the 2 requirements. 1, the application of force or show of authority, and 2nd, the submission or obtaining physical control. And what we're saying is that this court has had different interpretations of common law of arrest. And when we look at those different cases, for example, Hodari D, and when we look for Barr v. Niehl County's decision, it is obvious that the reasoning that common law of arrest is mere application of physical force constitute a seizure is a dicta within Hodari D because the court did not rely on this reasoning to come to its conclusion. However, in Barr v. Niehl County's decision, the court made it clear that because the suspect was stopped by the roadblock that, according to common law of arrest, a seizure happened. Therefore, when weighing these two cases, we think this court should turn to Broward v. Niehl County's evaluation and interpretation of common law of arrest when deciding this current case.
All right. Well, and then maybe we have a question for Sam. Do you think the phrase arrest and seizure have the same meaning? Your friends on the other side kind of suggest that it might. Do you see a difference between arrest and a seizure?
Yes, I absolutely do. Because a seizure can, so an arrest is when someone first acquires a seizure and then they indefinitely bring them into custody. However, petitioner argues that a seizure is only the slightest application of physical force, and we do not argue that. We argue that a seizure requires full physical control.
Well, I mean, Counselor, here's a question for Sharon. Let's just be, realistic here, right? In this case, the officer shot at this woman 13 times, right? 2 bullets hit her. She became partially paralyzed. How is that not a seizure? I mean, if you want to get rid of the common law, fine. If you want to talk about what's reasonable, this woman was shot 13 times. How is that not a seizure?
Your Honor, this is not a seizure because the officers never gained physical control of Taurus for 1 second, nor continued possession. And according to Broward v. Niehl County, it was clear that the suspect was detained when the roadblock stopped him. And also, the petitioner argued that the two farmers and the primary source that says seize it and carry it away in quotation mark shows that seize it does not mean taking a continuous possession of someone. However, carried away.
I could ask a follow-up question, please, Sharon.
Yes.
The reason why they shot at her 13 times, she didn't go down because she's like Superwoman, right? Not everyone's Superwoman. If you shoot me once, I'm going down, right? Maybe if you shoot Curtis, he'll keep going. But if you shoot me once, I'm on the floor, right? How can it be that this woman with superhuman strength was able to evade the police because she's Superwoman, right? She can't sue. But if you shoot like a little guy like me and I go right down, I can sue. How can the rule be based on the ability to withstand bullets, right? Is that really your rule?
No, Your Honor. We believe that we believe that the officers had probable cause to use that force because Taurus was obviously in a vehicle and she was not hearing what the officers were saying as she was under influence, and as she alleged that she couldn't hear what the officers were saying. Therefore, the officers had to stop her with the bullets, and because they couldn't stop the car, that's why they started aiming at Taurus to try to stop the driver from both crushing the officers between her car and the neighboring parkers, as well as ensuring the public safety by not having Taurus, who was under influence, to drive at that moment.
Okay. Any other questions?
Yes, counsel. You're saying that for a seizure to occur, do the police have to take physical custody of the person who is being seized?
Yes, we believe that the police has to have physical control and also be able to stop and detain the suspect.
So what if an army sniper shoots somebody from a mile away and kills them, but that person is never physically brought under the control of the police? What if they're never arrested, they're never taken back, they're just left there? Is that a seizure?
No, Your Honor. What we're arguing is that physical control means that there's a limitation of the suspect's ability to move around, and they wouldn't able to escape or move as free as well. And therefore, when the person was shot at the moment and that means, just as Broward v. Niehl County says, that person was seized because he was no longer able to move freely.
Doesn't getting shot affect your ability to move around freely to some extent? I mean, maybe it's not as drastic as what happened in Brower in my hypothetical, but surely Ms. Torres' freedom of movement was restrained to some degree.
Well, I don't think, sorry.
Go ahead.
Well, I don't think termination of freedom of movement is exactly the same thing, Your Honor, as control, because Torres was able to drive 75 miles to another officer. So she was obviously had the full capabilities and freedom of movement to evade the police officers, which means that control in this sense doesn't really apply because the officers weren't even able to meet the minimum requirements of force necessary to subdue her.
You may proceed.
Okay, so the petitioner argues the intention of officers to apply physical force was enough to constitute a seizure, saying that, quote, the impairment of Tara's freedom of movement is not required for physical force seizure, unquote. This was based on the false interpretations, as they cite Brower v. Niehl County's decision. And in their understanding, seizure was defined as any time when there is a governmental termination of freedom of movement through means.
Well, Counselor, if I can interrupt you, let me ask you a question based on the Broward case. Let's say you have a situation where they didn't shoot Torres. Instead, they called ahead to the highway patrol, and they said, we know she's driving down the highway at 75 miles an hour. Put a cement roadblock in the middle of the road. Put a cement barricade in the middle of the road. And then she can't avoid it. It's dark, she doesn't see it, she can't swerve, she slammed into the cement barrier. Is there a seizure there?
Yes, if Torres was stopped by the roadblock, yes.
Okay, but now let me change hypothetical. Her car slams into the wall and her car is wrecked, but then she gets out and walks on foot. Was there a seizure?
If she was eventually not in control of the officers, then that does not constitute a seizure.
But what's the relevant thing that's being seized? Is it her car or her person?
That's her person.
So when she slams her car into a wall, that's not a seizure then? I think you said it was a seizure a minute ago.
Oh, no, Your Honor, we're arguing that because Brower v. Niehl County's decision said that the person was actually stopped by the roadblock, not just the car, because that person was dead in the case. Therefore, when the person himself or herself was stopped literally, then a seizure has happened.
Okay, all right, thank you, Counselor.
However, in the actual case, the decision said that only when there is a governmental termination of freedom of movement through means intentionally applied that a seizure has happened, and only one shows intentional termination of freedom is one requirement, but not all that is needed. And secondly, the petitioners, as they argued in their previously, they quote Brower v. Niehl that, quote, it was enough that Brower was meant to be stopped by the physical obstacle of the roadblock, unquote. But they left out the crucial second part of the sentence, which is, quote, and that he was so stopped, unquote part. Therefore, when we look at it completely and correctly, the decision in the Brower v. Niehl case suggests that this court believes the obtaining of physical control is required for a seizure to happen. In addition, petitioner cited Florida v. Bostic, where this court decided that only when the officer, by the means of physical force or show of authority, has in some way restrained the liberty of citizens, may we conclude that a seizure has occurred, which goes against the petitioner's argument that only the intention is needed. In addition, the petitioner also cited United States v. Watson, arguing that original common law of arrest definitions as a submission is not required. However, the majority opinion states that, and a quote, an arrest, the taking hold of one's person is quintessentially a seizure, unquote. The definition of takes hold, according to the Collins English Dictionary, is gaining complete control or influence over a person or thing. Therefore, this court is in actuality believes that obtaining physical control is essential.
So which, Justice Brown, please go ahead.
So you're saying if there's an attempted seizure that is very unreasonable, so the police are behaving very unreasonable in attempting to seize someone, the individual they're trying to seize has no constitutional protection?
No, Your Honor. We're saying that there's this requirement of for seizure to happen, and also if we look at the current case, then we see that Torres did not give the officers the opportunity to communicate, to exercise, to respect her Fourth Amendment rights. Instead, she was so combative that the officers had no second choice besides shooting at her to ensure public safety and to meet their duty, to fulfill their duty.
Okay, you have about a minute left. You can proceed.
The petitioner cited 1704 Jenner v. Sparks' statement that If he had but touched the defendant even with the end of his finger, it had been an arrest, to argue that physical contact was enough to constitute a seizure. However, this decision was from a seminal case ruled in 1704, about 100 years before the Fourth Amendment was ratified. Therefore, the petitioner's argument that Jenner v. Sparks accurately represents the founding fathers' intention is refuted because there was no conceivement of the Fourth Amendment, not even the idea of establishing a constitution when the case was decided. Also, the criminality and police-citizen relationship was different back then. So this court should turn to Broward v. Niehl County, which was decided in 1989, to conclude that seizure requires a combination of the application of physical force and successful detainment of the subject. The petitioner also presented the hypothetical situation that if the standard of what is acceptable conduct from officers is based on whether or not the suspect was immediately taken into custody, it will allow officers to commit dangerous or reckless violations of the Fourth Amendment without sufficient recourse for victims. However, the petitioner neglects the limitations of their argument on the legal authorities and how that would undermine the Fourth Amendment.
All right, Counselor, I think your time is up. Very good. All right, now we have time for the petitioners come back up. Yeah, 5 minutes. Excuse me.
May it please the court. In this case, Ms. Torres was seized first based on common law definitions, which are the valid reasoning on which to base the decision in this case. And second, based on both California v. Hidari D and Broward v. County of Inyo, which do not directly contradict each other.
And finally, the rule following the common law definition for seizure creates a clear rule for officers in the field to follow that is easy to understand. First, the common law. Under a common law definition, submission was only necessary for a show of authority seizure. So a completed physical force seizure, not an attempted one, only requires the application of physical force with intent to restrain. And submission is not.
Let me ask you a question. What if a police officer walks up behind a suspect and taps her on the shoulder? Is that a seizure?
No, Your Honor, because the intent to restrain in that case was not present.
How do we know what the officer's intent was? Maybe he thought a firm tap would be sufficient to get the woman's attention and make her stop running.
Well, Your Honor, although this may be unclear in certain scenarios, in the case before the court today, the officer's intent was very clear.
No, I get that. But, Supreme Court, we got to decide big issues. We can't just decide, one case at a time. Big fancy Supreme Court. How are we supposed to figure out? Intent plays some role in your test. How do we know an officer's intent? That's a question we have to consider for ourselves.
Your Honor, if the officer just taps the person on the shoulder and if they're not pursuing them, this hasn't been a seizure because there was no intent to restrain. They would offer up handcuffs, like, can I arrest you? Can I grab you by the arm? No officer would ever tap someone on the shoulder and consider that a complete arrest or seizure because there was nothing leading to submission. There has to be a show of authority to lead to that submission, or the physical touch, which is attempting to restrain, and there's no attempt to restrain in a tap on the shoulder.
Well, what if the officer doesn't intend to effectuate a seizure, but the person he's communicating with believes the officer is trying to effectuate a seizure? Whose intent governs them?
Well, Your Honor, this would be decided by an objective review of the facts of the case that would happen in a trial court or an appellate court.
Right, but let me just take Justice Brown's question. Right, police officer walks over, taps you on the shoulder. You freak out, like, oh my God, he's trying to arrest me. And you stop. Right? Is it in general the intent from a subjective fashion? What did the officer actually intend? Or are you putting forward like an objective test? What would a reasonable observer think? Which test are you picking?
If the suspect if they reacted by running away and the officer then pursued them, then there has been intent to restrain.
No, the opposite. I'm saying officer tapped on the shoulder, the person, and they froze. They didn't move. They were afraid.
If they froze, a second later, the officer will likely clarify, hey, I'm just trying to ask you a question, and there will be no seizure because he was not intending to restrain them.
But my question is, at the moment the person freezes, is that a seizure at that instant?
No, Your Honor.
Let me give you an example, right? Officer taps you on the shoulder just to get your attention, not to arrest you. You have a heart attack and you drop dead. Can you sue for a seizure?
No, Your Honor, because that wasn't the officer's physical force that caused the heart attack.
And are you using an objective or a subjective test there?
An objective test, Your Honor.
Okay.
Whether an outside observer would have believed that there was objective intent to restrain manifest in that situation.
All right, good.
And furthermore, the alternative definition leaves many, many cases unclear. To address your earlier hypothetical, Justice Blackman, if someone hits a barrier and if someone gets out of the car and begins running away, the definition in Brower alone would leave that scenario unclear, because in Brower, the court was dealing with a case when the individual, Caldwell, was clearly stopped by the barrier because he was killed by that barrier. And Hadari fills a gap for cases in which the individual being seized was not killed, was not put in a straitjacket, was not fully and completely subdued so that they could not move. And Hadari clarifies that only the application of physical force, that alone is enough to be that termination of freedom of movement, and that alone is enough to be a physical force seizure.
So in conclusion, when you take the Brower and the Hadari cases, as well as the common law, we find a clear rule that is easy for officers to abide by. And based on that, we pray that this court will overturn the judgment of the Court of Appeals.
Excellent. Thank you so much, Counselor. All right, if the other team could please come back on camera. Wow, you guys are good. That was excellent. I want you to know how impressive it is that high schoolers can pull this off. This is not easy. When I was in high school, there's no way I could have ever done this. Not even close. I didn't know any of this stuff when I was in high school. I don't think I knew what the Fourth Amendment was when I was your age. This was really impressive. You handled yourselves so well with our questions. You see, the purpose of these questions is like not to try and make you look dumb, because you're not. You're all very smart. The purpose of these questions is to try to throw you off your game, right? You came into this session with a game plan, right? You said, here's what I'm going to say. Here's the points we're going to make. And everything that Ryan, Curtis, and I did was to throw you off that and try and push you from your game plan. And you did not push. You did not shove an inch. You much like Mrs. Torres, you kept driving 75 miles after we shot you, right? We tapped you on the shoulder and you kept going. Yeah, it's very impressive. It's very good. You had command of cases. You're talking about cases from the 1700s. You're talking about cases from the 1900s. I ask you what's relevance of common law. You say, oh, we don't need common law. It's malleable. That's a good answer. I ask you questions about, is this a part of the holding of the case? And then you tell me, yes, here's what the facts were. I give you these crazy hypotheticals about crashing into cement roadblocks and running out with your, bleeding and bloody, and you answer them. It's really impressive. I ask you policy questions. Won't this make it harder for cops to do their job? And won't this make it more difficult to, police? And you guys handle it. So I commend you. You should all be very proud of yourselves. This is the best year we've ever had. I've been doing this now for almost 8 years, and it's just stunning how good the students are getting. Every year gets better and better. I reviewed all of your briefs. I reviewed all of your preliminary arguments, and you've just leveled up. You've just increased your level, which is truly spectacular. So kudos to you guys. Wonderful, wonderful. And I hope Ryan and Curtis might have some other well wishes for you.
Well, I think if Josh had told me that the competition was amongst the law students, I would have believed him. It's hard to believe you guys are in high school, because you did a very good job. That's a lot of information to digest. It's a lot of information to communicate. Positions are very hard to hold on to and articulate when you're being challenged with questions, but you guys did a very good job. I work for an appellate court, so I see people do oral arguments before a court all the time. And that's just the hardest thing to do, is to maintain your position when you're being scrutinized and pushed and prodded with questions. But very good job. Were you guys nervous? I don't know how you couldn't be, because I would have been too afraid to have done any kind of competition like this when I was in high school. But these are just skills that are really valuable to have, even if you don't go to law school. Just learning how to communicate, how to frame arguments, how to explain things. I have a 4-year-old, so I use these skills all the time at home, teaching her. But they'll be very invaluable for you. Are any of you thinking of going to law school?
I am, definitely.
I am.
Oh, lovely. Oh, I think I sent an email to you or your coaches earlier. I teach a constitutional law class. I'm a professor. If you want to come to my class this week, you're welcome.
I definitely do.
We're very excited about them.
You come to all three of them if you want. So it's you guys are in Washington, right, Sharon and Sam? So it's basically at 1:30 on Monday, Wednesday, Texas time, which would be 11:30 Washington time. So it's an hour class. You're welcome to come sit in. If you raise your hand, I may ask you a question. But you get to a law school class like you're welcome to do it anytime. And are you girls homeschooled? Did I read that right?
I'm
I'm
completely
homeschooled.
homeschooled. I've been homeschooled and I'm kind of hybrid now.
Okay.
It's complicated.
That's okay. And you're in Austin?
Yes.
Yeah.
Oh, I'm in Houston. So if you're ever in Houston next year, you're welcome to come to my class to visit anytime you want. Truly, invitation's open.
I would love to.
Oh, it's true. Curtis, go ahead. I'm sorry we cut you off.
Yeah, it's good. It's important to be a bit nervous. It keeps you sharp. You stop being nervous, you get less alert. You get you're off your game. So yeah, I think of that as a tool, and the people who know how to use that tool have an advantage. I thought this was very good. I thought everybody did very well. This case has got a lot of ins and outs. It always surprises me. Each year, Justice Blackmun picks a case, and each year, I look at it, and then, it starts. The more I look at it, the more questions I have, the harder I think it is. And I think there were a lot of questions, and they came from a lot of different angles too. We're all thinking about different aspects of the case, and you did a really good job not only answering all the questions, but shifting between the different points and aspects of the case that we're trying to get at. I thought that was particularly impressive.
Excellent. Do you guys have questions for us? Open, whatever you want to ask, please go ahead.
I have a question about the case and the decision in the case.
Sure.
So when it was decided in the Supreme Court, in the very powerful dissent, Justice Gorsuch goes on at some length about how the Ginter v. Sparks and those other type cases do not represent all of the common law.
Yep.
So I have a practical question about that. Where would you go to find those cases?
Good question. Yeah.
The other cases that would contradict that, and is that true?
Well, that's why I think I asked you pretty early on those civil criminal cases. I think you probably knew what I was asking you. I was trying to pick up the Gorsuch one. And did you guys, Sam, did you read the case, the opinion that came out a few weeks ago?
Not yet. Because
okay, that's fine. It's long.
And we didn't want to, change, infect our morale. And
no, I know you probably did the right thing. I read it the day it came out because that's what I do. But you guys probably made the right call. So one of the issues was when we say common law, what does common law actually mean? Police departments didn't really exist in England at the time. You had what was effectively civil enforcement, where you would have basically a constable who would basically try to arrest someone to bring them to a court to pay some sort of judgment or something. It wasn't the way we'd have police today. And so a lot of the cases that Chief Justice Roberts cited for the majority concerned debt collection, right? I owe you money, give me, or you owe me money, give me this, right? And Gorsuch says these cases aren't really relevant. So Campbell, I think, asks a fair question. If you don't look at the common law cases for debt, what do you look at? I think that's basically what Roberts says. Like, look, this is the best we got. And then Gorsuch would probably respond, we don't necessarily look at cases. We can look at perhaps other definitions of seizure, look at the dictionaries, look at other sources. In other words, the common law cases may not be super helpful because they were in a very different context. It's also maybe the common law doesn't give an answer. Maybe England doesn't answer our question. Maybe we have to use more of a modern standard, which is somewhat at odds with what Gorsuch would usually say. I thought it was a very well-reasoned debate between the majority and the dissent. I thought it was close. I'm actually with the dissent after some reflection, but I think the case is close. If you go and you listen to the arguments and then you read the opinion, you can see they really had to struggle. And the Chief and Justice Kavanaugh were really, I guess, taken by that argument. But very good question. Earlier today, we had one of our judges was actually Rebecca Tableson, who argued the case on behalf of the government. She wasn't here around, unfortunately, but she was one of the judges before, and she actually won. And there was one point during the argument. So Rebecca clerked for Justice Scalia and Judge Kavanaugh. She clerked for both of them. And at one point, Justice Kavanaugh asked her, "Was Justice Scalia correct?" So one boss asking if the other boss was
There's
correct.
only one answer to that question.
The answer is the boss was correct. That's the answer. In one of the other rounds I did earlier, someone said Scalia was wrong. I was like, wow, that's good. That's like, but I respect it because you got to stick to your position. There's no sacred cows, right? You have to take your position. And if Scalia is wrong, then Scalia is wrong. He wasn't perfect. I think he screwed stuff up. What other questions you guys have?
Yes, I have a question regarding gender versus sparks, because we found that there are many cases that the actual petitioner argued in the Supreme Court relied on was before the Constitution was ratified or when the Fourth Amendment was ratified. And we couldn't find any actual documents online about those decisions. Then would it be admissible or would it be beneficial to include those cases, or should we refrain from those very early cases when arguing about something?
It's a good question. So first off, how to find them. It's to be clear, they're not always available online in easy places. Sometimes you have to go to a library. Did you girls find the cases somewhere? Were you able to find them?
It took me a while, but I did find the Countess of Rutland case. I believe we took the Jenner v. Sparks quote from
the brief,
petitioner
probably,
brief.
because we couldn't
That's
find
fine.
it.
It's competition. I mean, so Curtis is shaking his head. We're in Washington. Are you guys?
Sammamish.
What is that? Is that near a university or something? Or
It's near the Seattle area.
okay, so if you're near Seattle, UW is there, right? And you guys are right near UT Austin. I mean, in theory, putting COVID aside, you are allowed to go to a library, a law library. And if you went there and you told the librarian, "I'm looking for the Rutledge case," they would find it for you. They have these old English reporters, which I think most University of Washington, UT definitely have them, no question. These are really good universities, and they would find a copy for you. The other option, if you can actually get there, is interlibrary loan. If you check with your local librarian, they'll be able to retrieve it from some other university, or they might be able to find it on an online resource as well. So if there's ever a resource you can't find, ask the librarian, and if they don't know the answer, they'll find something. The librarians are really good. I've had only good experience with librarians. Curtis, you do a lot of primary stuff in your college, right?
It's hard without access to university database, and even then, it's tough. The law library suggestion is good. Yeah, I don't know if you know somebody with a university account, with a goes to a state university with access to JSTOR, and JSTOR is more for scholarly stuff, but those kinds of databases, then maybe, I'm not sure if that'd be a great investment in terms of time, but maybe find something there.
Yeah, always start with your local librarian. They usually know someone, and they know someone. I randomly I need to find a story from Hawaii from the 1960s, and my librarian knew someone at the University of Hawaii, and then it was done in a day. So librarians are good. But your other question, Sharon, is good. Why are cases from the 1700s relevant to before the Constitution was ratified? And I think what the court said and what Robert said is we have to look to this history. We don't want to just make crap up in this context, at least. We want to actually look to some history. And this is what you look to. You look to cases. And, but I think your response to respondents is, so what if in 1705 someone hits them with a mace? Who cares, right? We're living in the modern world, and why is that relevant? I think it's a fair response. It's not automatic.
I don't know what state are you in, Campbell?
Texas.
Oh, that's right. That's right. You mentioned earlier. In Ohio, we have Ohio Link, and anyone in the state can get a State Library of Ohio card. And for my court, sometimes there are resources we don't have access to, and I'll go to the public library system and order books there, and the whole university system I have access to through that. So I don't know what resources they have in Texas like that, but that's like what Curtis was saying, where I go to, even for my job. They actually threw away our law library. The county just dumped the whole thing. So we don't have that anymore. So sometimes I'll have to go look for it through the State Library of Ohio system. that way. But I don't know what, like I said, what resources they have in other states. Ohio's very good about having a strong library system where we could get those resources that way.
That's great. You have any questions about lawyering or going to law school, the process? Please, go ahead. No, nothing else? Well, look, I'll put yeah, go ahead, Sharon, please.
Yeah, I have a question about going to law school. So I think this is a very superficial one, but is going to a very good college makes applying to a very good law school easier, or is the LSAT more important?
No, not necessarily. If you go to and I don't want to say they're bad colleges, but even if you go to a not well-ranked college, you finish at the top of your class, good LSATs, you go to Harvard or Yale, right? Consistently, students at Ivy League law schools did not go to Ivy League colleges. Now there are plenty of them, right? Rebecca, I mentioned earlier, she went to Yale for undergrad and Yale for law school. She's a savant, right? She's a genius, right? I didn't. I went to Penn State for college, went to law school at George Mason in Virginia. Where you go to law school is not the end of the world. It doesn't define you in any way. So don't think too much about the ranks. There are people who go to Harvard that aren't that bright. So they're on this.
Definitely true.
Sorry. Kidding. You make of it of what you will. No matter where you go for college or law school, do the best you can. Be at the top of your class. Make lots of good friends, and you will thrive. The rankings of schools is so arbitrary. If you actually look at how the law schools and colleges are ranked, it's completely vapor. It's fake. There's no actual substance there. They have these formulas that make no sense. Like the U.S. News ranking is like it should be abolished. It's quite awful. It doesn't give you any useful information. Like how many books are in the library? That's part of the factor, right? Like who cares, right? They have all these random things about how you rate schools, and it's really arbitrary. So, but the short answer to your question, Sharon, is don't worry too much about the ranking of where you go. Go to the school that's the best fit for you, and that will make you the happiest.
Josh, what would you say about the trade-off between a school's ranking and the amount of debt you're looking at?
Yes, another student asked me that same question earlier. Scholarships help. Now, I wasn't independently wealthy. I can't speak for you, but I had to pay my way through college and law school. I graduated with $150,000 in debt, which I finished paying off a couple of years ago. I was already in my 30s. If you want to go to Harvard or Yale, they may not give you a full scholarship. If you go to school, maybe the top 25 instead of the top 15, maybe they'll give you some money. And as you sort of go down the ladder, they may give you more financial aid, which has trade-offs. And there are benefits to graduating college with that massive amounts of debt. So don't be beholden to the rankings. If you could make your life easier by not graduating like I did with $150,000. Now you guys are younger, right? You're all born after 9/11, if my math is right. I think so. So graduating with $500,000 in debt is not a pleasant thing for you. I'm mostly exaggerating, but it's true. Curtis, are you? Does Hills have a good financial aid package at Hillsdale? Are you?
Yeah. That's part of the reason I'm here is because it was cheaper than state school, so it's important to consider that. Don't graduate law school with $500,000 in debt. And where you go to undergrad, in terms of what law schools are looking for, GPA and LSAT scores are much more important than where you went.
Yeah.
So get a good education. Don't incur massive amounts of debt, and most importantly, wherever you go, do very well. And that's, I think, what's going to be the primary determinant of getting into law school. Not like the price tag or the brand value of wherever you went for undergrad.
And do you guys have any? Well, I guess Josh or Curtis. When I went to undergrad, I wasn't planning on going to law school afterwards. So I just got a political science degree and then I went to law school. Are there any majors, if you're thinking about going to law school, that are particularly beneficial to have, or does that have any kind of effect on what you're looking to do in law school? Like when you're thinking about going to law school from beforehand and you're choosing a major in undergrad, is there any guidance that you have in that way, or?
Is
mean,
that
What majors are you considering?
Yeah.
Oh, so I'm considering studying public policy and or international relations. Because because I came to the United States for middle school, like for 8th grade and 7th grade. So my parents are really interested in like studying for me to study like international relations and to really get to like the China United States relationship or kind of this international studies. But I'm more interested in public policy and I like United States government. But I heard that if we want to go to law school, then it's better not to take a major that is like law study or something related to law, and specialize in something that is more, specializing something that is more practical would be more beneficial if we want to go to law school. That's what I heard from some of the people around me.
I mean, look, pre-law is not a real major. I never really understood what that even was. Political science is fun, philosophy is fun, but make yourself rounded. Do what you love. You may decide you don't want to do law school, so do what you love. Oh, that's my advice for everyone. Do what you love. Do what makes you happy. You never work a day in your life. Truly, you never will. All right, I don't want to cut this short.
Read and write a lot.
Read and write as much as you can, though. I don't want to cut this short. We have another round coming in a couple minutes, and we have to get ready. So, if any of you want, my email is there. You can email me. Happy to set up a time to chat with you some other time. But I don't like rushing people. But people are in the waiting room. We got to let them in for the next round. So please email me if you want. Come to my class, but always stay in touch. Okay.
Thank you so much.
This was so much fun to participate in.
Thank you. Our pleasure, girls. Thank you so much. Sharon and Sam, thank you so much.
Thank you.
Take care.
Thank you.
Bye. You too.
All right, turn the recording off.